everyone. Thanks for joining us on Chicago Tonight. I'm Brandis Friedman. Here's what we're looking at. Governor Pritzker won't be hitting the campaign trail alone. He names his new running mate today as he seeks another term. What can be done about the growing cost of Chicago's police misconduct settlements? And from birthright citizenship to Planned Parenthood, what to know about the recent Supreme Court decisions. And now to some of today's top stories. A big win for President Donald Trump as the Senate narrowly passes his tax bill despite 3 Republicans voting against it. Vice President J.D. Vance cast the tie-breaking vote in favor of the bill after lawmakers split 50-50 on the measure. The bill includes $4.5 trillion in tax cuts while making steep cuts to Medicaid, food stamps, and green energy tax credits. The nonpartisan Congressional Budget Office says the plan would increase the national debt by more than $3 trillion. Not a done deal, though, as the bill now goes back to the House for a vote, which Trump is urging lawmakers to get done by July 4th. Governor J.B. Pritzker has named his running mate to join him on the campaign trail for a 3rd term.
I'm Christian Mitchell, and I am so excited to be your next lieutenant governor. I was really lucky growing up. I was raised by a wonderful mother who was a nurse for 38 years in the NICU at Rush University Hospital. I had a grandfather who stepped in and filled the void for me and was a sergeant in the U.S. Army and a union steelworker. They both taught me what it was like to care about your family and work really hard. And I know when we've got to take
In a video released on social media, Pritzker says former Deputy Governor Christian Mitchell has the experience needed to serve as lieutenant governor. Mitchell also served 3 terms in the Illinois House and replaces current Lieutenant Governor Juliana Stratton on the ticket as she is running for U.S. Senate. The Chicago Police Department is under fire today over its involvement in a federal immigration raid last month. Some older people say they witnessed CPD helping ICE agents conduct mass arrests outside a South Loop immigration office on June 4th, which sparked protests. The city's Welcoming City ordinance prohibits city employees from helping federal immigration agents in nearly all cases. A city council panel today demanded an independent probe be conducted. CPD's community policing director Glenn Brooks says officers didn't know a mass arrest was underway when they arrived and left the facility once that became clear, and then provided public safety traffic control, which he says is permitted. The full city council is scheduled to vote on the order July 16th. Up next, 2 perspectives on the city's costly police misconduct settlements right after this.
Chicago Tonight is made possible in part by the Alexandra and John Nichols family, the Jim and Kay Mabey family, the Polk Brothers Foundation, and the support of these donors.
The cost of police misconduct is a growing problem in Chicago. Taxpayers have already spent $189 million just this year to resolve misconduct lawsuits. That's compared to $107 million all of last year. Our next 2 guests argue different ways of approaching that problem, one by addressing the staggering clip of lawsuits, the other addressing police misconduct. Here with more on this are Paul Vallis, senior fellow at the Illinois Policy Institute and former candidate for Chicago mayor, and Antonio Romanucci, a civil rights attorney who represented George Floyd's family and other families impacted by police misconduct. Gentlemen, thanks to you both for joining us.
Thank you.
Paul Vallis, starting with you, please, what do you think are some of the factors that are driving these police misconduct settlements, both in volume and settlement amount?
Well, I think runaway juries is part of it. There's no limit, there's no caps, there's no, there's one, some of these firms, there was a recent settlement for 2 individuals, $120 million. There was another settlement, $50 million for 10 years for 1 individual. The bottom line is there's just simply no limit on the lawsuits altogether. Now, there are other states who do have limits, who do have structure governing those lawsuits, and even the federal government, permits there to be a cap on like private lawsuits and things like that. But the problem with cities and municipalities is government becomes a deep pocket, and I think that's what you're seeing here.
Well, and it's not all runaway juries. The city is settling some of these before they come to a jury.
Well, they're settling it because there's this perception here that if they don't settle it, because there's no limitations, they're going to have to pay more. And let me point out that there has been, I think the city's paid $1.1 billion since 2010 in lawsuits. About $700 million in lawsuits that were paid on police lawsuits in particular did not involve them proving the individuals were innocent, rather it was associated with police misconduct. I'm not making a value judgment, I'm just pointing it out. That's according to a study that the Sun-Times did. But there's, I think, 200 police cases, there are 200 cases in the pipeline right now that could cost the city, if past patterns suggest, could cost the city anywhere from $1 billion to as much as $2 billion in taxpayer-funded settlements.
Tony Romanucci, you argue that legal action and financial costs, financial pain, that is how change gets made in many cases. Do you think the city of Chicago and the police department are responding by making change?
I don't think so. Part of the problem that we're dealing with is we're not fixing the problem. If we don't fix the policing problem first, then what we're going to continue to see are problems that develop over decades. What we're seeing right now, if you see a payment being made tomorrow or one being made a month ago, it's not a problem that started even a year or two ago. It's been decades long. The city of Chicago has not addressed these problems. Even under the current consent decree that they're cooperating with, we're not going fast enough, we're not doing enough. So if we don't fix the problem, we're going to continue to have these results. And what we're talking about, what Mr. Vallis was saying about the $120 million, those are wrongfully convicted people. And to me, it's quite insulting to think that wrongfully convicted individuals should have caps placed on what they receive. Just because they may have been poor or disenfranchised or marginalized when they went to prison doesn't mean that they are not entitled to full and fair justice.
I just have to respond to that. There are so many cases, and you can have a conversation with the city lawyers about the cases where individuals who have been released, obviously because of police misconduct, but between them and the state's attorney, they knew these individuals were guilty. They not only settled for massive settlements, but they were made millionaires. And if we had about 30 minutes, I could go through a litany of those type of cases. The point is, I believe that if there's police misconduct, people need to be compensated. I believe that if people go to jail, and unfairly, and the police have committed misconduct, they need to be held accountable. That's not what I'm talking about. But I'm talking about massive lawsuits, massive settlements. One law firm made $112 million in a single year and pocketed $42 million. So it's not like, even all that money is going into the hands of those individuals who were victimized. Also, let me point out that many of the individuals who are getting out and are being released and are settling for massive settlements are also individuals who have committed crimes in the community. And how about the victims? I mean, because the overwhelming vast majority of these cases where arrests have been made, the individuals who were the victims of the violent crime were in fact Black and Latino, and poor Black and Latino. So what about those poor families?
So I do want to get to some of the, and I'm going to come back to you, I promise. But I do want to get to some of the reforms that you talk about, Paul Vallis. You suggest public education and judicial awareness, federal damages caps, reform the state's certificate of innocence statute, pursue civil claims against fraudulent lawsuits, and establish a special litigation division within the law department. And this is all included in the commentary, the op-ed that you wrote in the Chicago Tribune. I only want to talk about a couple of those because, like you said, we don't have 30 minutes. But you say some of these convictions are vacated based on a technicality versus actual evidence of innocence, and that somehow leads to these multi-million-dollar settlements. How so?
Well, I think they just try to maximize the benefits on any settlement. So there's been cases where clearly the police misconduct occurred. These individuals were innocent. They were unjustly convicted, and certainly they're entitled to settlements. But there have been enough cases out there that the city has argued time and time again where the individuals, in fact, did commit the crime, but the police, through their investigations, committed malpractice. So the question is, should they be getting multi-million-dollar settlements in the process? So I'm just speaking to these cases that have been made, and you could look at the public record. And in some cases, the judges have actually, intervened to point that out. So at the end of the day, I'm simply talking about reasonable caps, because you have to understand, while the city has paid over the last 15 years $1.1 billion out in lawsuits, it's probably closer to $2 billion, because the city has to borrow in order to pay that, and the city has to take out insurance, and obviously you have the rising insurance costs, and the city is at the point now where they can't even get insurance for these big mega cases. So you're talking about a city that has $1 billion, $1.2 billion structural deficit, facing maybe another $1 billion in settlements.
In the case of there are some federal instances where there is a cap.
Where there is a cap, and some states have caps that provide, for example, if you're in prison, for each year you're in prison, you're allocated a certain amount. So there are different ways of imposing caps.
And you're granted that certificate of innocence in exchange for agreeing not to pursue
That's right.
civil suit.
And all I'm talking about is having a reasonable discussion on how we can contain the costs. So instead of, so that, because ultimately the property tax
containing the costs,
exactly.
right? Because taxpayers are paying for this. Tony Romanucci, you say that the police department, while they are cooperating with the consent decree, they're only at 16% after what, 10 years? I forget, a lot of years.
It's been since 2017.
Exactly. What do you propose? How should the police department be making change to avoid the kind of police misconduct settlements that gets the city into the courtroom?
So first of all, I just want to say that a lot of the proposals that Mr. Vallis puts on the table is a clear denial of due process. That's our 14th Amendment right. What he's saying, placing caps, amending the certificate of innocence, by definition, if you're wrongfully convicted and you are exonerated, you did not commit the crime, by definition. So what is it that we have to do in order to start? You have to start with training. It has to start with the bare bones basics. A lot of agencies across the United States do not train like they should, and they don't continue the training because it costs money. It's expensive. But guess what is more expensive? The problems that come from lack of training. So if you start with training, you will then resolve many of these litigation issues that are being discussed here today, because you're not going to have police misconduct. I would like nothing more than to be able to put myself out of business. If I cannot prosecute police misconduct cases, if I don't have to represent the mother or the father or a child who lost a loved one who was killed by police, I would be happy. I would be more than happy to have this discussion and continue this discussion at a round table and make sure that this doesn't happen.
Is there any other recourse for people who've been wrongfully convicted or maybe injured after a police chase, whatever it might be? Is there any other recourse beyond a civil suit?
Well, there are some recourses, but clearly, our system of democracy, the 7th Amendment, says that you are entitled to a civil jury trial. And let me tell you, it's the juries that do the hard work here. Because when there isn't an agreement, when there isn't a settlement, there is a trial. And then juries decide, juries of our peers. And they make the decisions. Not the lawyers, not the city lawyers, not the private lawyers, but a jury. And a judge oversees that jury to make sure that trial is conducted properly.
Look, that was 30 seconds.
Look, we could spend an hour going through these cases of individuals who were made millionaires in part, and not because they were proven innocent, but they got off because of police misconduct and technicalities. The bottom line is, if you go to your website, you talk about $1 billion in settlements. I mean, what percentage of that were kept by the law firm? This is a cottage industry, and they're making a tremendous amount of money. I'm simply talking about reasonable caps. Nothing I've suggested here is in any way unconstitutional. In fact, many of my proposals have been vetted by attorneys for the city, and these are recommendations that they have made. Let me make one comment. I think I'm out of time.
You're right. We are out of time.
This
has been a robust discussion, gentlemen, and I thank you both for joining us. I look forward to continuing this sometime in the future. Paul Vallis, Antonio Romanucci.
Thank you so much.
Thanks so much for having me.
Thank you, Paul.
Thank you. Good to see you.
Up next, wrapping up a busy term at the U.S. Supreme Court, we look at the impact of some of those major decisions. It's a wrap on this year's term for the Supreme Court, and they just delivered a slew of decisions on cases ranging from birthright citizenship to funding for Planned Parenthood. But as the justices break for the upcoming holiday, they could be hit with some emergency appeals from a variety of sources. Joining us to discuss more are Carolyn Shapiro, professor at the Chicago-Kent College of Law, where she is founder and co-director of the Institute on the Supreme Court of the United States, and David Applegate, an attorney at Williams, Barber & Morrell. Thanks to you both for joining us.
Thank you for having
Welcome
me.
back. Carolyn Shapiro, there's this ruling that says that federal judges cannot make nationwide injunctions or court orders to prevent carrying out decisions like Trump's birthright citizenship order. What does that mean? Because a lot of people think that this one is about birthright citizenship, but it's not quite.
So the court did not reach the question of whether the birthright citizenship executive order is constitutional or not. And I'll just bracket that to say it's wildly unconstitutional. And that's part of the problem with what they did say. What they did say is that judges, lower courts, and probably even the Supreme Court can't issue an injunction that prevents the defendant in the case from acting with respect to people who aren't themselves plaintiffs. It's not actually about nationwide injunctions. It's actually about being able to restrict a defendant from doing something that everybody agrees is illegal with respect to people who aren't actually in front of the court. And the court did allow for some ways in which some relief might be available, whether through a class action mechanism, which is hard to do and which they've made harder, or by providing relief, say, to the states who say, well, we can't actually function if the birthright citizenship goes into effect anywhere in the country. So we don't know for sure what the full implications of this order, of this opinion are, but I can say that I predict that in the coming weeks, there's going to be a cascade of litigation around the country in cases having nothing to do with the Trump administration, cases involving injunctions that may have been in place in some cases for years, where defendants are going to come in and say, well, wait a minute, we should be able to do things with respect to people who were never in front of the court as plaintiffs. And it's going to be extraordinarily disruptive.
David Applegate, your thoughts, your reaction to this decision?
I both agree and disagree with Carolyn. This case is not about the merits of birthright citizenship. It is a procedural case. I see it more as a separation of powers case. Justice Barrett made plain in her 6-3 majority opinion that this is based on the Judiciary Act of 1789, in which Congress gave the courts power to do certain kinds of things. And not one of them is to grant nationwide injunctions at the trial court level or any other level that include parties not before the court. She traces this back historically to the difference between law and equity in the English courts and how this power did not exist. Where I disagree with Carolyn is that it is not clear that the Trump executive order is illegal or unconstitutional on the merits, because this case has never been decided. The phrase in the 14th Amendment that relates to birthright citizenship is all persons born or naturalized in the United States and subject to the jurisdiction thereof. Subject to the jurisdiction thereof is not defined in the 14th Amendment, but the 14th Amendment explicitly gives Congress the power to pass enabling legislation. So Congress, it seems to me, and not the courts, is the proper forum. Let we, the people who elect the legislators, who make the laws in what is supposed to be our self-governing democratic republic, let Congress determine what's subject to the jurisdiction thereof means. As far as the court's own jurisprudence, the case that's most commonly cited, the Kim Wong-Ark case from 1898, is distinguishable from what the Trump executive order deals with, because there the parents were lawful residents of the United States. This order deals only with parents who are not lawful permanent residents. And that's probably a minority view, but that is my view, and that's the way I would argue the case, if and when it gets to the merits, which it probably will 2 or 3 years down the road.
I'll just stop and say, actually the order reaches plenty of people whose parents are here legally. They're not here permanently. But the order extends to children born to people who are here, say, on student visas, on H-1B visas. They're here perfectly legally. And the order says that they are not entitled to birthright citizenship. And in addition, there is a statute that provides that gives more full weight to the 14th Amendment that does exactly what the 14th Amendment itself does. And there is plenty of research and historical and legal commentary across the political spectrum about what the words within the jurisdiction mean, which I think we probably don't have time to go into in deep
Much
detail.
like the previous segment, we do not have as much time as we would like, because I would like to move on to another ruling the Supreme Court made that Medicaid patients cannot sue states to enforce their right to pick a medical provider. The provider in this case being Planned Parenthood. Carolyn, I'll start with you again. What is the broader impact of this ruling?
So the case involves a statute that Congress passed and said, we're going to give money to the states to run Medicaid, and when states run Medicaid, they have to do certain things. And then the question is, who gets to enforce when the state says, you know what, we're not going to do that? There's been a fair amount of litigation over many decades about exactly when an individual who's going to be getting something from that statute, like a Medicaid recipient, has the right to bring a lawsuit. Just 2 years ago, the court held in a case involving healthcare providers that they could bring a lawsuit against states that were not living up to their obligations under the statute. But in this case, just this last week, the court said, well, individual Medicaid recipients and Planned Parenthood itself can't go to court to say that South Carolina, in this case, is violating its obligation to make sure that everybody can use the healthcare provider of their choice.
David, same question.
This, to me, is a very easy case. The question is not whether South Carolina can get Medicaid funds from the federal government and then choose not to allow someone to use them at Planned Parenthood or any other provider of their choice. The question is what is the proper remedy? And there have been, as Carolyn has said, cases that do find private remedies under statutes, but the Supreme Court decided 6-3 that this is not one of those cases. There is no private right of action. In particular because Medicaid was passed pursuant to the spending clause, and that under the court's own jurisprudence does not give rise to a private right of action, meaning that you or I or Carolyn or anybody else can sue.
I don't have the right to sue over that.
Right. What happens is the federal government says, you're not meeting one of the 80-some requirements to get this Medicaid money. We'll cut off federal funding. You, the state, will now have to pay for this Medicare on your own.
In this instance, are there concerns about the ripple effects of Medicaid paying for Planned Parenthood services and access to those services?
Absolutely. I mean, already federal Medicaid dollars cannot be spent on abortion.
But Planned Parenthood, we know, provides many other services.
Exactly. So if the impact of this decision is that South Carolina can decide not to pay Planned Parenthood to provide mammograms, to provide pap smears, to provide treatment for sexually transmitted diseases, et cetera. And that means that for many people who've been going to Planned Parenthood for their health care, they will not have a place to go and they will not have a provider.
We've got 1 minute left, David. Supreme Court also ruling last week that parents in Maryland can pull their children out of classrooms that discuss LGBTQ themes. Your reaction to that ruling?
This case is most interesting to me because Sam Alito wrote it, and he is probably the #1 proponent on the court, and it has been when it comes to religious rights cases. Religious rights, and the Chief Justice, when he votes in the majority, gets to decide whom to assign it to. So I don't think it's a coincidence that Sam Alito wrote this opinion. I think it is based on sound precedent dealing with the Amish who don't have to send their children to school past the 8th grade, with respect to the Jehovah's Witnesses who do not have to stand up and pledge allegiance to the flag because they regard God as a higher authority.
And of course, in the dissenting opinion in this case, there were concerns about parents insulating their children from different viewpoints, which are which are going to happen in public schools. But that is where we'll have to leave it. I'm sure we'll have more to talk about because the Supreme Court is busy. Carolyn Shapiro and David Applegate, thanks to you both for joining me.
Thank you for having us.
And that's our show for this Tuesday night. If you're looking for things to do in the Chicago area for the long holiday weekend, we have got you covered with our Chicago Summer Festival Guide. It's all at WTTW.com/festivals. And join us tomorrow night at 5:30 and 10. We explore how President Trump's so-called Big Beautiful Bill could affect Chicagoans who receive food assistance. Now, for all of us here at Chicago Tonight, I'm Brandis Friedman. Thank you for watching. Stay healthy and safe, and have a good night.
Closed captioning is made possible by Robert A. Clifford and Clifford Law Offices, a Chicago personal injury and wrongful death firm that contributes to public safety policy and guidelines.